want to just lead by thanking Brian for getting us organized before the holidays so that we could possibly wrap up our business by year end. Um, we'll start the meeting by, I'll state the conflict of interest policy. Members of the subcommittee are advised of their duty under the State Ethics and Government Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. So with that, I'll just draw your attention to the email that Brian sent on the 5th of December with our meeting materials. It includes an agenda, a resource guide that he's drafted, as well as the committee report from October of 2020. And our first order of business is to approve that report. So if anyone would like to move for approval of the October 2nd, 2023 committee report, I'll be glad to hear the motion.
So moved.
Is there a second?
Second.
Any discussion or debate on the motion? Any changes needed to the minutes? Okay, all in favor of the motion? Okay, it passes. So the subcommittee report is approved. Thank you again, Brian, for doing that for us as well. And so now we'll move right into our substantive discussion. So we really resolved a lot during our last meeting. I'll just remind everyone what we've resolved. So we decided we do not think that the state bar should make succession planning mandatory. And of course, we did a lot of research into that and decided that was going to be our recommendation to the Issues Committee. We also decided that we did want to recommend that the state bar and encourage and enable voluntary registration of a proposed trustee, and we'll talk a little bit more about that title, through the state bar's membership portal. We all thought that was a good idea. And then we also agreed that we would recommend to the Issues Committee that the state bar create a publication on planning for unexpected absences. And of course, that is the document that Brian sent out to review in advance of the meeting. So there are a couple questions for us to think about today. Are there any other educational sort of efforts that we think folks should undertake or recommendations we would make? And I think that, and then some discussion around the title. So Brian, with that, I'd love to turn it over to you and you can take us wherever you'd like to.
Absolutely. Well, thank you. And we are, like Ashley said, we're looking at this this revised publication that I drafted. I think the best thing is just going to be for me to share my screen, so we're all looking at the exact same thing. And the as we had talked last time, we're kind of trying to figure out what is the best focus for the state bar. The first version of this resource was really kind of trying to broadly discuss succession planning and try to encourage folks to have some sort of succession plan. But our conversation at the last meeting kind of shifted the focus of this publication to really the role that the state bar plays when we have to step in the trustee process and deal with these emergency situations, the unexpected absence. There's a lot of different resources and a lot of good information, a lot of workshops, CLEs, et cetera, from the Bar Association, Lawyers Mutual, on kind of a larger succession plan question. And just to facilitate those different conversations, which of course can vary from practice to practice, whether you're a solo or a member of a larger firm, medium-sized firm, the different practice areas. Clearly, there's a lot of variables at play when we're dealing with succession planning. But when we're talking about the unexpected absence, that's when the state bar gets involved. That's when the state bar expends its own resources, both time that staff takes, as well as financial resources when we have a trustee appointed, and so forth. And so we wanted to focus on the unexpected situation. So I rewrote this to really focus on these emergency situations. I know one thing that we need to kind of agree on is this role that a lawyer can play in another lawyer's practice or in their life when they're stepping in, when they are the person that could potentially step in and be a resource to the state bar and maybe the practice itself by being appointed as a trustee. So we'll get to that in just a bit, but I just want to go and quick overview of this publication again, as well as the very last page, which is a new addition for folks that need to just simply print something out and maybe register somebody in this unexpected absence scenario. So really, again, the first page is just a description and really something to encourage everybody to have some sort of plan. When you need to plan for the unexpected, we can talk about solo practitioners, and the rules of professional conduct focus on solo practitioners specifically. Rule 1.3, comment 5 talks about the need for solo practitioners to have some sort of plan if they cannot go to work the next day. But really, this affects lawyers in law firms. I know I've held or had CLEs where I've had people come up after the CLE to ask me, are you telling me that I've got say 3 different partners? There's 4 of us all together, and we all do different things. You tell me that if one of those folks cannot come into the office, then I am going to be responsible for that person's files. I've never dealt with that area of law. The answer generally is yes, because if you're in a law firm and you are practicing law together, then there needs to be some sort of understanding. Of course, it's the client has retained the law firm, even if they're getting services from one particular lawyer, and it becomes this, I think, this important point to drive home that all lawyers need to develop some sort of plan, because maybe if somebody within the firm just doesn't have the competency to handle those matters, at the very least, they still need to know where your passwords are, because maybe there's a different trustee that needs to be appointed. Maybe it's not you, the partner. Maybe it's it's just bringing somebody else in, even if a trustee isn't appropriate in that particular scenario. The point being that anybody who is practicing law needs to have some sort of plan. And I think that's where we try to get into the details here, the first steps that are outlined in this resource. Again, we're trying to just get people thinking about this. I think that was one of the themes that I've heard from our conversation. There's only so much that we can do. We don't want to mandate anything, but we want to encourage folks to think about it and really kind of empower them. Maybe by asking a couple of good questions, like these first steps that I've listed here. Just start thinking out loud. Describe your practice. What types of cases do you handle or have you handled over the past couple of years? Maybe just writing these things down suddenly might give you a big picture of what you've done and what you have to deal with, and maybe it even increases the importance in your mind of getting something set up. Who are your clients? If somebody stepped into your practice today because you could not attend, you couldn't come into the office, and maybe it's going to be for whether it's a permanent or a long-term situation, is somebody else going to be able to step in and figure out just where you left off? And after you think about these things, tell that to someone, communicate that with somebody. Maybe it's a paralegal, maybe it's a peer. It can be a variety of individuals, but you got to talk to somebody instead of keeping this information in. And then number 4 there is identifying this proposed trustee. That's the term that we need to kind of settle on here. Of course, the State Bar's trustee process is something that is, and Barry can speak to this and correct me where I'm wrong, but generally speaking, the trustee process is something that yes, the bar will appoint somebody to wind down a practice. That really only occurs in solo practice situations, because again, if you have partners, if you have some other members of your law firm, the law firm is expected to kind of take care of its own. And so having this person labeled as a proposed trustee is one of those things that I don't know if it's a potential misnomer, because it's not even guaranteeing that, even if we're talking about a solo practitioner, that this person that you, the lawyer, have named is going to be appointed by the court as the trustee. There's a number of different considerations there. Of course, the bar works with the court. The bar will reach out to maybe some of those that were familiar with the lawyers, the unavailable lawyers practice, things of that nature. So, identifying somebody and calling them a proposed trustee is kind of both appropriate and perhaps not quite on point, because really this role is meant to be a resource for anyone who is looking for information about the unavailable lawyer's practice. And we go on, and you can see in the description here, where we're talking about the person that knows kind of what sort of organization method did you have? Did you have files all in your office, or did you actually keep some files in storage somewhere? this person may not know your passwords, but perhaps this proposed trustee knows who has your passwords, where they are, where can you access them. They know where the keys to the garage are, basically. And so that's something I think we do need to discuss of what's the appropriate title for this. I know we've thrown around a variety of different options, but those are just the first steps that are outlined here. The third page just covers resources. These are all hyperlinked, so people can easily access the resources on larger succession planning questions from the Bar Association, Lawyers Mutual, different jurisdictions. We've talked about these things in our subcommittee meetings. There's a lot of different resources out there. And so, rather than recreating our own, we can just point to these other resources that exist out there that may be helpful. And then we've talked with some folks, both the Transitioning Lawyers Committee with the Bar Association, as well as Lawyers Mutual Consulting Services, or the Law Practice Exchange that really facilitates the transfer of ownership. If somebody wants to take those extra steps of going beyond the unexpected absence, but to actually engage in real succession planning, there's resources that are really at their fingertips. The last thing that you'll find in here is this designation of a proposed trustee form. I created this form after our last meeting when we were talking about, we want to make this this voluntary designation available in the membership portal that's on the State Bar's website. Unfortunately, we are kind of one project in a line of other projects, a number of which are being prioritized, like the CLE changes, the law firm administrator for the membership dues cycle coming up, and a number of different just outstanding projects as we have, as a State Bar, as an agency, transitioned to a completely new database. I've not been given a timeline on when this can be done, other than just they're going to have to wait until the first quarter of 2024 to address it. I know it will not be done before the end of the year. So, that being said, even when that comes into existence, there's still going to be some folks that particularly the ones that we really want to designate somebody, that may not be comfortable going onto the member portal and actually making this designation. So we wanted to make a resource that was simply available to everyone through this resource, and you see it right here. It's just kind of a quick description of what is this person, what is this role meant to serve, and gives an opportunity for the attorney to put his or her name, as well as the name of the proposed trustee. And just kind of, again, like a little bit of a reminder there. Maybe this person is signing off on, I've named this person. Yes, I have communicated. You see here right after they've named the individuals, I've communicated with the proposed trustee about serving this capacity, and my proposed trustee has agreed to do so. I would imagine this language would be in the membership portal too when we launch that opportunity as well. But it's stuff like that we just kind of outline, what the person that's making the designation is kind of agreeing to, that they understand the roles, that the other person who's being named understands their role. And the little, kind of very quick sort of, I don't know if I want to call them check boxes, but just really bullet points. I made it a square, so if they felt like they wanted to check it, they could. But it's really just trying to kind of highlight some of the things. These are kind of the critical things that you need to share with this person. So as well as, of course, information on where you can send that. So that's the resource, the revised resource that I had created after our last meeting. I'd be happy to talk with you about any questions, concerns, any changes, and of course, the name of this role, I think, is something that we want to finalize. I think there's a lot of different options out there, and none of which are maybe perfect, none of which are necessarily wrong, but maybe they could just simply be better. So I think that would be a really good use of our time here if we like this resource and the direction that we're heading in this situation.
So why don't we start with feedback on the resource? What do folks want to share? Do you like it? Want to see changes?
I have a question about it. First, Brian and Ashley and the committee, great job. This is good work. Looks like you guys are close to the finish line. So kudos for that excellent work you have done so far. My questions are fairly straightforward. I apologize, I missed the last meeting. On the form, should we add a date on the form. I didn't see a place for a date. My thinking there was if, you sign it, you appoint a trustee and you don't have a date on it and you decide later to appoint another trustee. Or maybe the second form should say this supersedes the previous one. That was just a technical thought there, but I thought the form looks good, in my opinion. And the other my other question relates to, and you keep alluding to this, Brian, inventory lawyer versus proposed trustee. This form seems to pretty clearly relate to the trustee versus the inventory lawyer. I read the notes and I thought they were two separate persons, but maybe I'm confused.
Yeah, I think that's the thing we're struggling with. Let me first just address your first point. Absolutely, we need a date on here. And I'm going to put a date right underneath the signature line of the attorney. So yeah. That's that. Thank you for pointing that out. Yeah, the trustee, I think that's the name. The inventory lawyer is what we were using before, saying that, this person just kind of generally knows what's going on with your practice. But I think that name just maybe it didn't feel perfect to us. And so we were, looking around and thinking, well, this person, ideally, especially in this scenario, I think the person that's designated by a lawyer they're filling out this form, we're kind of presuming that they would hope that this person, should there need to be a trustee appointed, that it would be this person because they have that information. But that's, of course, again, imperfect, because it's the trustee role that someone can play for a law practice is one that is specific. It's specific to the state bar. It's specific to what the bar applies to the courts for, to wind down the practice, take possession of the files, the practice, the trust account, all those different things, and they have specific duties. Really, this person that we're talking about is someone who might be appropriate for a trustee, but they might also not be appropriate. They're just somebody who knows where the keys are, where's the schematics for the for the building, whatever it might be. So it would be, this person's really going to serve as a resource to the state bar in trying to figure out how do we best address the practice that has been kind of left wide open. And it could be, again, it could be a solo practitioner, it could be a member of a small firm. If none of the partners are really, I would like to think that partners are talking to each other, but I know that doesn't always happen. There's a firm, but everybody's kind of doing their own thing and they don't really know what everyone else is doing in that building. And so again, that's why it's kind of this role being a resource, and it might be a resource to the local bar, might be a resource to the state bar, the court, whatever it is. But this person is supposed to just kind of know generally how the office was organized and where the kind of provide those first answers to questions of how do we access the office? How do we access the files? Does anybody know where the keys to this filing cabinet are? Where were the other files kept? They were kept at a storage facility, somewhere else in town, things of that nature. And so the title is one that I think we're struggling with, and understandably so. So I think you're correct in kind of feeling, are we talking about two different people? The trustee versus this role potentially is two different people, depending upon what happens with the state bar's appointment of contact reports, things of that nature.
But for this form and this discussion, we're talking about one person, and we need to decide on the name, whether it's proposed trustee or inventory lawyer or something else. The form clearly says just because you're a proposed trustee doesn't mean you're going to be appointed ultimately to do that.
Right.
So is that really the question? What is the name of this person? Inventory lawyer, proposed trustee, or so if it's inventory lawyer, you simply plug in here inventory lawyer on this form versus proposed trustee. Is it as simple as that?
I think that's
perfect. Okay.
Yeah, that's what we'd be doing. Yeah.
Great. Okay.
Yeah.
Thank you.
Brian, I think you defined it so well as proposed trustee that I like that. Inventory lawyer, like you said, just doesn't feel right. But the way this is spelled out, it's kind of like more like a point of contact than anything else. And I think the definition within the form covers that.
I agree with Matt.
I agree with Matt as well. I like the proposed trustee because really the proposed trustee is as a quasi trustee in many respects, and you have defined it, and it's not a permanent situation. I would also add perhaps down after in the paragraph after name of proposed trustee, you have only wind down of my law practice. Would something like a prolonged absence or wind down should the need arise? Because it's not just the wind down. There's somebody to step in for temporarily for a prolonged absence.
So that's a tough spot. Barry, I'd welcome you to step in here as well, because I know we've dealt with that situation where someone has contacted the bar for the appointment of a trustee because someone has, let's say a lawyer has a prolonged absence, maybe for 6 months, because they need to go to treatment for whatever reason, substance abuse, whatever it may be, and they need to step away from the practice. They're a solo practitioner. We've never been in a position to kind of prop up a law practice. And I don't mean that just financially, but just appoint somebody who can essentially step in and take over the practice and run it, keep collecting on fees and things of that nature. I think that has been done. I know that it's been done informally. Right. And I think that's something that I know in talking with Root, who kind of trained me in this process many years ago. There were certain situations where a trustee to wind down the practice wasn't necessarily appropriate, but somebody needed to step in and take care of some business, some immediate business. And the best situation was kind of an informal arrangement that the courts all knew about. And there was one person that stepped in and basically was able to work with the paralegals to maybe get certain client files to different clients and all that. It's something that really was, it was kind of a feel situation as opposed to this is strictly by the rules. And I think in those situations, it may have been appropriate, but it's hard to kind of articulate exactly what somebody can and cannot do, especially when you're dealing with confidential client matters. That's why we usually get that order that appoints the trustee and specifically grants from the court the authority to the trustee to access those materials. But as far as keeping a practice alive for somebody to come back to, we haven't done that lately. But Barry, please feel free to tell me. I don't know what your experience has been.
My experience is the same, Brian, and you articulated it well. I mean, just about 100% of our appointments or our inquiries about trustees are for wind down of an attorney's practice permanently. And so it's very seldom. We have had some inquiries about maybe a temporary disability, but like you said, we've handled that informally and not with the appointment of a trustee. As to the name of the proposed trustee, I was just going to chime in that I like that myself, just personally, because I think it creates less confusion, with our whole process. And I rather than an inventory lawyer or some other nomenclature, I think the proposed trustee keeps it consistent. And so and I think the resource materials are excellent. I think this would be something that's very helpful to us to disseminate at the local bar meetings, or if we have our continue our district bar get-togethers, yearly get-togethers here at the state bar. That's something we could also distribute there, and this gives us some great talking points for that.
So Eben, to your question, do you think it would be, and I guess this is for the whole subcommittee, understanding that when we have to get formally involved, we're looking to appoint a trustee for the permanent wind down of a practice, but we do get contacted about these extended absences, which we don't necessarily appoint a trustee, but there have been, we just know, local bars, can often kind of, they gather together. They help out the folks in the community. And they're really helping both the clients as well as the lawyer where they can get back in the saddle, so to speak. But we do that very informally. So would it be, I guess I don't want the form to kind of dissuade somebody from if they run into that situation. I know somebody's going away, they've got to get treatment for some sort of medical condition, and they're going to be out for 6 months. And they've reached out to me, and maybe somebody else has reached out to me as an emergency situation. They're off in South Carolina receiving treatment, whatever it might be. But the court and others have reached out to me. They know that I know the person's practice, but I'm only supposed to assist in the wind down. And it sounds like some other folks, there may be an opportunity to kind of just keep things afloat, keep the paralegals on staff with some supervision from attorneys. The court has kind of empowered this mechanism to really assist the clients in receiving legal services that they had previously expected and retained. Should we change the language here to be a bit more general in the sense that, I provided my proposed trustee, I'm looking at that paragraph that you were highlighting, without sharing client confidences, I provided my proposed trustee with information about the structure and organization of my law practice, so that my trustee can propose, or my proposed trustee can assist with, instead of the wind down of my practice, maybe just any matters concerning my law practice in my absence, or something like that. I don't know if we feel comfortable with that, or do we stick with just what we I guess by administrative rule can and do act upon, and historically I know what the State Bar Council adopted as a policy back in, I guess it was 2011, I believe, or 2012, about stepping in and winding down a practice when there is nobody else to do that. What do you think, Evan?
Well, a handful of times, maybe just 3 or 4 times in my career, I've helped informally with lawyers that are temporarily and sometimes prolonged absent from their firm, collecting fees, trying to manage the cases, keep the clients informed. And so Barry's right about I think that's sort of the community gathering together. I don't want to say that maybe another form ought to be designated for a prolonged absence, but either way is fine, Brian. I think I'll listen to what everybody else has to say about whether we need to modify the wind down language.
I don't know if anybody else has thoughts on that. And I know I'll just say, the purpose of the form, the purpose of this exercise is really to ultimately generate or have lawyers designate somebody who can be a resource. And that resource is someone that the State Bar can rely upon. But then in other situations, when somebody is absent, if we get a call from a senior resident Superior Court judge saying, we know this person's out for the next 6 months, and we just want to make sure that we can kind of keep the ship afloat as a community, not looking to wind his practice down or anything like that. And we say, well, we as an agency don't really get involved in those situations necessarily, but we do have this person that the lawyer previously designated that knows kind of, again, where the keys to the castle are. So we want to pass this information on to you. That can still be done in those informal processes. So perhaps the form just serves its purpose of having a lawyer designate somebody to serve in this role who can be the resource, whatever the situation may be, formally or informally. So perhaps maybe, I guess I'm kind of indirectly saying is maybe we do just leave it as is because it's appropriate within the scope of what the State Bar does, what we're statutorily and by administrative code empowered to do. But yet, if there's some informal flexibility that's necessary, this still serves that purpose.
Yeah, I'm good with that, Brian, leaving it as it is. So
I am too. I think, we're gearing this more towards small and solo firms, and the more complicated we make it, the less likely it's going to be completed, I guess is probably the word. And We start muddying up with other terms. I'm not sure it's going to have the desired effect.
Right.
I'm sort of thinking through this. This clearly, in my mind, addresses the trustee issue. I'm not so sure that it addresses the pre-trustee issue, whereby we need somebody to step in and keep things afloat. Seems to me that the trustee steps in when the bar or somebody has decided it's time to wind down, and that this form and our historical practice takes care of that. I guess I'm thinking if another, so I think, can another lawyer step in and handle a lawyer who may be getting treatment? Can it handle that person's practice ethically? I'm thinking, aren't there confidences that would be shared? And I mean,
Absolutely. And
Yeah, I mean,
that's what we have when we've had those conversations
Yeah.
with folks in the community who said, listen, as far as what maybe is being proposed of having the bar appoint somebody to just step in and take over the representation, we can't do that. And there's client confidences and so
Yeah.
forth. You would need court intervention of some sort. The court would have to basically empower somebody to step into those shoes. And of course, you still have the issue of client choice. Are there conflicts?
Right,
I
exactly.
ran into that in one of those informal situations before, where somebody who was asked, the two lawyers were agreeing to kind of make some continuances, things of that nature. And then they realize, oh, one of his clients is actually somebody that I've got an active case against. Didn't realize that at the time. So there's all those little things that come up when you're get into this. How do we just keep things open? Which is why we don't get involved with those situations. We've talked to courts, and we've talked to judges, we've talked to other attorneys, and we just have to advise them. There's a duty of confidentiality. You're dealing with confidential information, and that's something that you can't access without some sort of express consent from the client.
The client, right.
And even, I mean, I guess that's the thing. To me, that's the biggest one. If the court enters an order granting you that ability for this limited purpose, the courts do have the ability under 8428, I believe it's subparagraph J, to enter orders that are necessary to protect the interests of clients. Yeah. It's very broad in that regard. And so to the extent that a court wanted to enter such an order, I think the court is empowered to do so. But again, that's not something that we usually facilitate and particularly use our resources on. So and that's
I was thinking that might be the better approach. The state bar, to use Marcy's favorite quote, sort of stays in its lane by doing what we have done historically, but the judge or the judiciary has the power to do what we can't do. And so there is some ability to protect these clients and for the court to appoint somebody for this very limited purpose that is a pre-trustee appointment opportunity, so to speak. Is that right, Brian?
I think that's right. And I think that's something that we don't necessarily need to make a part of this resource, because that's not our process. I think that's just something that we can address if it comes up. And at Barry, I mean, how often have you seen some of those informal situations?
It's very rare, and I would just add, the court is usually in those situations. The court's in probably a better position than anyone to make a determination who should step in at that point and take over for that particular attorney. So,
okay, all right. Well, some great thoughts. I think it sounds like we may have dare say consensus on this resource, the form being as is, and maybe the term of a proposed trustee, which of course I did use in this this revised version as well. So were there any other thoughts on let's stop the share so we can look at each other full screen. Are any other thoughts? Barry, you had something? Barry.
Yeah, I was just going to mention, the thought had occurred to me then, if the one proposed trustee is, for whatever reason, maybe death or disability, him or herself, is not able to serve, should we also provide for, a secondary proposed trustee in this form? But then the contrary to that, I mean, I'm thinking, well, it's going to be hard enough to get them to propose one, much less two. So, I think it's a good aspirational thing, but I don't know that it would be practical to have two.
Yeah, I'd love to hear the subcommittee's thoughts on that point.
It's like Todd's suggestion to put a date on it. Once lawyers, I think, fill this out and designate a proposed trustee, if there is some problem down the road, they can renew the form and put a different date on it with a different trustee. That certainly would seem easy.
Brian, I have a question
Yes.
about the form, and I apologize if I missed this. So right now we have a written form to be emailed or mailed in, which, that poor membership director. And so I would just encourage you that if there's a way to automate some kind of form that people can complete online that will port right into your system, I mean, save hours of staff time. So I just wanted to mention that. And I know you said you got folks working on it. So hopefully that's what they're going to do. I just wanted to mention that.
Right. I completely agree with that. And I think ultimately the membership portal, I would predict, will be the primary mechanism. And that's something that even this revised version of the publication references, this ability to put something in a membership portal. I would, in that regard, I guess, want to talk about the timing for this. We clearly would not publish this until after we get to the January meeting and present our final recommendations and so forth to the council. And by then, I would like to think that there's a better timeline. Because again, we kind of have an end of the year deadline for a lot of these different things that are prioritized right now. And so, then we wouldn't need to change anything. But if it's going to be for whatever reason, a month or two, I don't necessarily think we want to delay publishing this resource until that database process or project is completed, because that's just one of those things that I fear the snowball effect, right? So but I do think we need to have some sort of automated system. And I think this particular form, the thing that I was going to also make it once we kind of settled on all this, is make it a fillable PDF as well, so people can type it in. And I believe we would be able to put this, even if we just had the form itself on the website that people could fill out, even if it's not in the membership portal, at least then it can get electronically to us, so we don't have to sit there and process everything. The good news, of course, is that ultimately this is really dealing with a very limited data entry and a data field. It's really just one new field for every single attorney profile. That I know.
How many licensed lawyers do you have?
We have 32,000.
Yeah, I would be willing to wait 2 months until you could automate it. That is not a good use of your staff time. I don't feel like.
Hey, that's music to my ears, Ashley. I'm fine with that. I don't want to, cause unnecessary delay because of these external things, but you're right. The automated process, the ability to do this in the membership portal would be crucial. And also that's a spot where I think we can't do it for this year, but for next year, for the 2025 due cycle, I believe we've talked about this before, and I think this committee recommends it. Please clarify if I'm wrong, but make this a part of the renewal process. When you have to go through and you're checking if you have an IOLTA account, do you want to designate a proposed trustee? It gets some information right in front of you. Maybe has even a link. I would anticipate putting a link to this resource that people can learn more, but then just that single data field where folks can they can enter something, but at the very least they have to click past it to complete their annual registration process. I think that's part of this idea of encouraging folks to think about it. That was the plan.
I don't know what other people think about timing. If you think we need to go ahead and but to just move forward and use paper, what are folks' thoughts on that?
Ashley, I agree with you. I think it's a resources issue. So I think your suggestion was right on.
Okay. So maybe our recommendation could be, unless there's anyone who disagrees, that, as soon as it can be operationalized some way within the system, that it be deployed.
That sounds good.
Does anybody worry that that'll mean it'll take too long or not be prioritized? Matt's the president.
Oh, Todd's the
I
president.
mean, Todd's the president.
Matt can have it. I can tell you that. He can have it already. I can tell you. Thank you, Ashley.
I mean,
Give it to
Todd
Matt.
can make it happen.
Yeah, good luck with that. No, I mean, I agree with the automation piece, and I do wonder, we can just keep track of it and monitor it, Brian. If by this report ideally will be done in January, it will be adopted, whatever recommendation this committee makes. And then we can just monitor, Brian. I would not like to see it sort of, linger forever because we can't put it through the portal. So if we could keep an eye on it, if there's something that is going to be a great delay, maybe we bring it back before the council somehow, the issues committee somehow in April.
I think that's great. I would expect to have some sort of timeline in January.
Yeah.
Okay. But then, yeah, to me, if we're sitting here in March and I still haven't gotten an update, I'm told, well, we just haven't gotten around to it yet. Then I feel like I'll be contacting you all just to let you know that maybe it's time to just move forward. But yeah, and I'll look into the other options of placing this as a fillable PDF in some sort of form on our website that then feeds into our database or just makes it electronic. We have that with grievance complaint forms and other forms. So that to me is kind of an at least moment. But I know I remember we talked last meeting about some of the folks that we really want to fill this out just are not tech savvy and may have more difficulty. So having this as an option, is still a good thing to have, and we'll be able to kind of deploy it as needed.
So it sounds like we've all approved the resource and the name of the proposed trustee. Does anybody not agree? Okay, so is our work done, Brian?
I think so. I think the only other things that we were talking about, for one, I'm going to draft a report recommendation, kind of summarizing our discussions here for presentation at the January Issues Committee meeting. And, we had talked previously about the PMBR modules and all that kind of stuff. But I think the consensus was we're going to hold off to wait and see how the first PMBR cybersecurity module launches and the response to that. And I think in those regards, we can kind of see how these initial efforts really are, how they're accepted, how people interact with them, see if there's a level of success and if there needs to be more in the form of either that PMBR-esque module, a CLE that gets put on, or things of that nature. But you can be certain that I know as far as like the ethics staff, we do still get questions about succession planning. We continue to kind of beat the drum, so to speak, on this topic, whether it's journal articles that we're drafting in the ethics section or otherwise. So it'll stay at the forefront of our conversations in other aspects. But for this committee, I feel equipped to draft up a report that, of course, I'll send to you, Ashley, for your final approval. But then we'll be ready to present in January.
Okay, well, with that, I want to thank Brian and Barry for their support. I think this has been a great, very efficient committee. And Brian, really appreciate you drafting those materials. And I think doing just a really terrific job. So thank you. And thank you for everyone on the committee for all your feedback and participation. Does anybody have anything before we adjourn? Okay, we're adjourned. Happy holidays, y'all.